Hello, good afternoon, everyone.
Good afternoon.
Welcome, sir, Mr. Woye. Good afternoon, sir. How's it going?
Fine, I'm okay. And you?
Yeah, very well. I'm fine. Thank you, sir. All right, welcome everyone to today's webinar. My name is Akitunde Udo, and this is another opportunity to learn, right? And we are glad you could join us today. At ESQ Trainings Limited, our mission is to expand the frontiers of continuous professional learning with courses and trainings across various areas of practice. We have tagged this webinar series, the Launch Hour webinar series, as they are slated to hold at 1 p.m. during the lunch break. They will hold 2 times every week, Tuesday and Thursdays respectively. And after every session, we'll provide you with resources in easily accessible formats on the go for everyone who is interested. Today, we are actually considering joint venture and other structure in real estate financing. And some of the context of discussion will be around the structure of real estate financing, deal sharing and exclusivity, the pooling of economics, distribution of returns, payments of promotional interest, and clawback provisions. And we also have another subtopic called governance issues around joint venture. Please note that if you have any questions while the webinar is going on, please type them in the Q&A box there, and in due time, they will be answered. It is with great delight that I introduce to you our speakers for today. We have Mr. Woye Famojuro, partner of Famsville Solicitors. And we also have Mr. Victor Samuel, senior associate at Udo Udoma Belo-Osagie. We are honored to have you both as our panelists today. Without further ado, we're going to get started. I want to hand over to Mr. Victor. He's here to join us on the call. He's meant to be the first speaker, but Mr. Woye, you can have the floor, sir.
Okay, thank you very much, Akintunde. So I want to say a very big thank you to everybody for joining this webinar. And as a matter of fact, it's actually to educate all of us with respect to joint venture and financing. So coming to the topic that we have before us, pooling economics, distribution of returns, payments of promote and clawback provision and governance issues. I would like to say that, I mean, from my experience in the last over 10 years, with respect to real estate and construction, I can say that this is the time where joint venture has actually been very prevalent. And the reason is because there's actually an opportunity and the opportunity is growing. Basically, what joint venture means is the meeting of the mind. Basically, it's a partnership between 2 people. So, I mean, the 2 people we are talking about here is actually a landowner and also from the investor's point of view, basically. So, I mean, there are a few landowners everywhere in the world and even in Nigeria that they really don't have finances and money to go along with their project. So, I mean, and there are also other developers that would also come in to say that I've got the resources here and I can also build, but there are other parameters to this. I mean, it goes beyond the landowner and the developer meeting. So the usual situation is there's also another situation whereby even the landowner might actually have the money to do this, but they don't have the technical knowledge. So they bring in a technical partner. We can still see that as more like a joint venture too. So it's a meeting of the minds, basically. So from what I've said, I mean, there are other reasons why people go into partnership for a big return. Where the finance is not actually there, they also bring in the finance, a finance house to make sure that all the lending and all the finance they need comes together. So basically what pooling of economics means is that there's an opportunity with landowner and also an opportunity with the developer. So both parties come together to make sure that this goes very smoothly. So, I mean, there are other parameters when it comes to certain key considerations. Going to my second slide, when it comes to joint venture, it's actually very critical in the sense that due diligence cannot be overemphasized in a joint venture structuring and relationship. And the reason is because um, you are meeting someone for the first time and you're going into a project together, you go in blind, and you also need to do your due diligence on the part of the landowner. You need to find out from the developer or anybody that is building or the joint development partner if they actually have the funds and the resources to build. I mean, beyond the funds, the technical know is also very important. I'm sure everybody is aware about the collapse of the building that happened in Ikoyi. It has really changed the way the joint venture project and real estate how it's being done. This is because Lagos State government, in consultation with other regulatory bodies, LAPSCA, approval office, I mean, they've actually put a very scrutiny and procedures, when it comes to you getting your approvals and everything. So, I mean, the person you are going to a joint venture partner with has to be someone that your vision and your goals align. I mean, there are lots of people in the industry that you discover that they're actually there because of the money. I mean, beyond the money, your reputation is also very important. You don't want to be a project whereby at the end of the day, it will fail. You understand what I mean? So there's also the non-disclosure and non-circumvention part of this, which are part of the key considerations. So the non-disclosure clauses has to be the standards and agreements, from the name clause to profit sharing to a non-disclosure clause. So there are also times where there is only one title document that I don't know if I show my slide so that everybody can see, because I don't think I can do that from here.
Okay, so I'm with the slides and I'm sharing it. I hope everyone can see.
Okay.
Can anyone see the slides?
Yes, I want to believe that everybody can see this slide. So regarding the escrow considerations, I mean, they are when the title document for the project is the title deeds for the property should be well kept somewhere, because it's only one title document that is available for the property. That means that it needs to be kept as an escrow. You can nominate a finance house. Both parties can say, okay, let's nominate the first bank or any other bank to keep the title documents, so that at the point of where subscribers are fully paid for the units and they need to sign off the title deeds to them, it doesn't become, I know where the title deeds are not. So another key consideration is also structuring considerations. There are special purpose vehicles which are basically set up for this. Most particularly, the foreign investors are always invested in the SPVs, and the use of their capital to finance this project is paramount. So I think I would also like to say that in joint venture structuring arrangements, there are different levels to it. It could either be a public-private partnership or someone also going into a joint venture structuring with, an individual landowner or a company that's actually acquired a large stock of land. So I want to share my experience a bit. I think about 5 or 6 years ago. I think about 9 years ago, when one of the largest real estate organizations in Nigeria wanted to go into a joint venture partnership with a landowner somewhere in Ikoyi, and it was very important that we had to sign the deed. I mean, the developer was not comfortable, landowner was not comfortable putting the title deeds in an escrow. And so what we advise the developer to do is that, come on, if the landowner doesn't want to put the title in an escrow, you can as well prepare title deeds and leave the names of the subscribers or annotees blank. I mean, it's just a safety net for you when I go into transactions like this. And this is because sometimes, when all these things are not tidied up, at the end of the day, it becomes a stumbling block in arrangements like this. So I would be going to my fifth slide, distribution of returns. So basically, this is required to be when this is always required in either a tripartite joint venture agreement, that involves a lender, which is a bank, and the returns and timelines for payments has to be expressly stated. Because when you go into a project of any magnitude, you understand that there are returns. That there is a financial return for everybody. So if you don't properly incorporate this into your agreements, it can actually be a problem. So also tax considerations on the amount to be paid, either in capital gains tax or personal income tax. Well, most especially when you're perfecting your title, at any level, there are statutory payments that need to go to the government. So I think both partners have to agree who and who is going to pay, who bears responsibility of such payments. From my own experience in the past, the developers are always the one that usually concern themselves with the bidding approvals and getting all the other approvals. The landowner has to perfect the title and assign title to the eventual buyers. So when you're considering joint venture agreements that needs to be executed, you need to put it in proper perspective, how returns will be evenly distributed. There needs to be a consensus ad idem. So I also like to share my thoughts on the payments of promotes, basically. So for my first slide here, I've said that in a JV where a sponsor assembles the finance for a real estate transactions, basically there are always two people in when it comes to payments of promotes. There's always a sponsor and there's always an investor. So basically, the sponsor is the one that assembles the finance for the real estate transaction. If, for example, you want to go into a real estate transaction and you haven't got the finance, you could either reach out to a sponsor to say, okay, you'll be the one in charge, sort out the finances, And there's always an investor side to things, First and foremost, there are bankers and non-banker lenders. Individuals can come to say that, okay, I'll be the one to sponsor this project, and my return on investment has to be guaranteed. The profits that we're getting from this has to be guaranteed. So and what the sponsor receives, what is known or what is called as promote or carried interest. And this has to be put in place when you are going into this kind of project. So on the last part, I said one thing investors should remain alert to in a joint venture is a double promote. A sponsor is a running fund while investing simultaneously outside the funds. So I would also like to say that when it comes to the issues of relating to governance, I would say that there are a lot of regulations that one has to bear in mind when going into projects like this. Hold on, let me go into my. So let me just continue the issue of the payment of promotes. I've said that sometimes promotes can be paid quarterly or as agreed by parties. You need to agree on how much or how the promote will be divided and will be shared by all the parties. Sometimes sponsors negotiate multiple things of return. That means it could be staggered, it could be agreed on how these things the promote rates will be shared, and there'll be changes along the way. It's not cast in stone. So going to slide 8, which is the clawback provisions. I might be a bit very fast. Clawback provisions are basically like a safety net. Because when you are going to a project, you should always have at the back of your mind that there could always be defaults. Going back to the global financial crisis in 2018, there was a financial crisis, and to prevent a future fault with customers and employees, you need to insert those clawback provisions. There are safety nets, for you to insert in the agreement, which protects everybody. So a clawback clause, like I said here, is a special contractual clause used mostly in financial terms for monies paid for services to be returned under special circumstances. So it's not more like a refund, clawback, it basically means penalty. So it basically means penalty. For example, if a landowner doesn't have title, this clawback provisions will eventually protect the developers, and ensure that all payments and investments into the project are recouped, basically. So I think I'll also be going to the last slide, which are governance issues. I mean, a lot of deadlock situations usually arise from conflicts of interest. When in a joint venture contract, generally the common one is that when you go into a project like this, you have people that don't agree on even on things that they've actually agreed from the onset. There's still a break in communication, and you find out there's a deadlock. So parties could either decide to either delegate the execution of the business plan to a management team. So there's a possibility that there's a breach of contract by one party to the agreement. Most times obligations are not fulfilled by one party to the agreement, sometimes resulting to the failure in the arrangement. So, but when you also come to regulatory compliance issues, the issue of compliance cannot be overemphasized. I mean, so there are different regulations or regulatory bodies that are in place. That even when you're going into a joint venture contract, that if you don't have lawyers that will actually advise you, let me give you an example. Some developers or some people go into contracts even without getting building approvals, and you find out that they still go on and do those developments. And when the government comes in, they put a stop work order to your project, and this defeats the whole purpose of your investment. So I mean, one should always be mindful of the governance issues surrounding a joint venture. So and there are also complicated tax planning arrangements. Yeah, we should decide who will be responsible for tax. Tax avoidance is very critical to the success of a joint venture arrangement as it is. So, but I would like to say that when it comes to joint venture, the first point of call should be the contractual agreement that we put in place. After both parties have agreed and you said that, okay, this is how the project will go, and contractual is very important. All those clauses, safety nets that needs to be in a contract cannot be overemphasized. I mean, from the layman's point of view, you probably want to go with the contract without putting those things in place, but it is as well very important. Then there are a few trends there and there. When it comes to joint venture in Lagos and within coastal areas, I think one of the reasons why this is actually very high is because Lagos is actually one of the most populous. It's actually the most populous state in Nigeria, and you see that people are coming up to develop a lot of projects, and the bank as well are also financing all these projects, and they're not left out of it. Usually what banks do is to make sure that when they give collaterals or when they give facilities for a joint venture project, they secure the assets and they also secure the title. So these are very critical issues. So, but I also allow Akintunde to also continue. If there are any questions or anything, I'm ready to respond. Yeah.
All right, thank you very much, sir. That was very insightful. Thank you for sharing that in details. At this moment, we don't have any questions yet, but please, if you have any questions, you can use the Q&A tab there on your Zoom app, right? So we can have some questions for the guests, and they will be answered in due time. Okay, I see a question here. It says, can you speak more about the issue of promotes? I did not quite get it.
Okay, so let me try and go back to Let me try and go back to that slide. So basically, payments or promotes. I think I should. It's important. I need to take it a bit slow. In a joint venture structuring or agreement, where a sponsor, there's always a sponsor and there's also the investor. The sponsor is actually responsible to assemble the finance for the real estate transactions. And there's also another person, which is called the investor. So there's a sponsor and there's an investor. So I don't know, maybe you quite get regarding that. So I mean, once the bank or a non-bank lender has been paid their return on investment, these two groups share the profits. So that means that there's an investor and there's also a sponsor. The sponsor is the one that goes around to get the finance for the real estate transaction. So after the whole project and everything has been done, whether the person is a bank or a non-banker lender, I mean, the return on investment has to be shared within these two groups. So what the sponsor receives, in terms of return on investment, is what is called the promotes, carried interest. So that is what the sponsor receives. So there's also something called a double promote. A double promote actually pertains to when a sponsor is running a fund, while the investor is also simultaneously running the funds outside. So that means it's basically a collaborative effort. So, but in order of priority, I mean, the sponsor, receives what is called the promote or carried interest. So I don't know, maybe I'm able to explain that very well, So basically, the sponsor is the one that assembles the finance for. So let me give you an example. If a Periwinkle Investment Nigeria Limited or owns a particular land and Woye Famojuro is the sponsor. So what is the person that goes around to either Woye Famojuro or First Bank, First Bank is a corporate entity, is the banker, will go around to source for the finance for the real estate transaction. So now the investor is also Periwinkle, which is the landowner. You understand what I mean? So I mean, what the sponsor actually receives, in terms of return on investment is called promote or the carried interest. But there are also instances where it's called a double promote. A double promote is where what you guys are getting, the carried interest you're getting from the transaction is both for the sponsor and also for the investor.
Hi, Woye.
Yeah, hello.
Hello. Yeah, it's Victor.
Okay, Victor, how are you?
Yeah, I'm good. So sorry guys for joining late, and sorry for cutting it. I don't know if I can also chip into your explanation on the promote.
Yeah, please go on.
Okay. So the reason I just want to chip in is if possible to go very granular, just for the sake of people that have not seen it done at all, so that go back to the basics. I think it might be easier if we understand exactly how this promote thing is calculated, because it took me a while to understand it myself at the time when I started working on it. So just to add to what you've already said, so typically when, as you mentioned, investors, equity investors, they will most likely want to have some certainty with respect to their returns. Yeah, so so say an equity investor may want to have assured returns of, say, 8% internal rate of return. So if I'm giving money to a sponsor, I want when profit comes in, I must first get up to 8% of my investment before we can share what is left. Now, so after I get my 8%, that is when we can then decide the sharing formula. So we can say what happens now is between myself and the sponsor, I now get 75% of the remaining returns, and the sponsor gets 25% of the remaining returns. So what it really means is sponsor bears a lot of risk, right? And that's what we should bear in mind whenever we are advising our clients on whatever side we are. So an equity investor gets the assured internal rate of return, and then the profit is then divided. So as you very correctly said, what the sponsor then gets is termed promote. So yeah, pretty much. So exactly what you said, but I just thought, I don't know, maybe to discuss the calculation if it would help.
Yeah, that's fine.
That's right, yeah.
All right, thank you very much, Mr. Woye, and thank you, Mr. Victor, for your contribution. At this point, we will move to Mr. Victor's presentation on the same topic. So, Mr. Victor, you have the floor now. Thank you.
So first of all, again, I would like to very much thank Woye because he stood in for me. So thanks a lot for taking, and apologies to everyone. I had some serious technical difficulties joining in. So and thanks for the wait.
Mr. Victor, you can show your face. You're allowed to do that. All right, great. I'll share your slides now.
Okay. Okay. Please, I just thought to mention upfront that this presentation is made by both myself and Woye. So please, if you're asking questions, it's targeted at both of us. So anyone that's too difficult for me to handle, I'm going to let him field it. So my name is Victor. I'm a senior associate at the law firm of Udo Udoma Belo-Osagie, and I would like to thank everyone again for the wait and for this knowledge sharing opportunity. And I hope that at the end we would have given you something to add to the knowledge you already had before our presentation. So next slide. I think I'm just going to skip the first slide. Yeah, well, that's about my firm, and everything can be found online. And the content. Some of these things have already been covered by Woye, so I may skip some of them or not go into them in detail. Moving on. Next slide. Right. So I put up this slide just to show us the immense potential of the Nigerian real estate market. And the opportunities that abound, which is why project developers and sponsors keep coming up or keep trying up with innovative ways of funding real estate projects, particularly commercial real estate projects. I'm not going to dwell on these figures. My understanding is that at the end of the presentation, the slides will be shared with everybody. So that's just to tell you how much untapped potential that the real estate market has in Nigeria, and why from project developer side and also from advisor side, we need to keep working on innovative ways to raise funding and execute projects in real estate. Next slide. Yes. So just briefly, a general overview of real estate financing. Mostly we are used to the traditional forms of real estate financing, equity capital, self-financed property development. So where a developer uses his own funds saved or from family or from friends, Um, you have the loan capital where developers, take loans from different lending institutions, commercial banks, mortgage banks, etc. You have the JV arrangement, which is what we are discussing today, and which is where we'll focus on. And then some other non-traditional real estate financing sources like REITs, that's real estate investment trusts, crowdfunding, etc. As you are all well aware, we are going to just focus on joint venture development today. We all know. I'm going to. I would like to assume that we all know what a joint venture is. So I'm not going to dwell on this, but just to mention that a JV can be incorporated or unincorporated, and the form of JV you adopt will determine, at the end what documentation you need to put together, and some of the key issues or terms that you need to look out for in putting together your documentation. And Woye had already mentioned that a typical joint venture arrangement involves the project sponsor and the equity investor. So, and then the project sponsor could also be the landowner or another entity altogether that seeks out projects and then partners with both the landowner and the equity investor. So you could have more than two parties to the joint venture arrangement. Why consider a joint venture arrangement? Of course, access to resources. So project developers that don't have land in choice areas for development will gain access to such lands by partnering with landowners. Shared risks, flexibility. So particularly if you are using an unincorporated JV, you are not tied to it's not a marriage, so to speak. So you are just coming together for a specific business, and then you have the flexibility to explore other avenues. You have a new market penetration where a prospective investor in a market that is not quite savvy or does not have deep market knowledge in that field seeks to partner with entities that have deep market knowledge in that field. And then access to funding, of course, where project developers have access to investment, investors, equity funding. Then one of the key reasons to also consider a JV arrangement is, coming together of two entities or more will result in a synergy, and so you end up developing a more suitable project rather than a substandard output, which may result from a single party undertaking a project of such a magnitude that it's not equipped to undertake. Next slide. So I'll be looking at the chronology of, so I merged the chronology of JV arrangement with the key documents because somehow they tie into one another. So in executing, in consummating a JV arrangement, of course, you have to, your client, or you have to identify a potential JV partner and conduct due diligence on the JV partner. I know that we have spoken about JV due diligence on JV partners. And then typically, now all these agreements don't have to be executed, but in your typical JV arrangements, the first agreement parties usually enter into is a non-disclosure or non-circumvention agreement. So particularly two parties that have not conducted transactions together before, you want to be sure that your client is protected, that whatever information your client is divulging to the other party is protected under a non-disclosure arrangement, and then non-circumvention, which will ensure that the party to whom the information is disclosed does not go behind the disclosing party to execute the project by itself or with other third parties. Following an NDA, yes, and non-circumvention agreement, parties could enter into a term sheet otherwise called heads of terms, which sets out the general commercial um, terms that the parties have in mind for the execution of the project. Now, depending on whether the JV will be incorporated or not, you might at this point need to incorporate an SPV, right? And then in the incorporation of the SPV, you may have to prepare shareholders agreement or a joint venture agreement if the entity is not an incorporated JV. In some cases, parties could also have both agreements with the provisions not necessarily overlapping, but it might just be best to have everything in one document. And then if it's an incorporated JV, you're thinking of your MEMATs, your articles of association and memorandum. And then the equity contribution, because after setting up the JV, then the partners are then expected to contribute their equity. And also if they need access to debt finance, because in addition to the equity, they may seek debt finance. This is the stage where they do it and achieve financial close and then commence execution of the project, after which profit is distributed. And most times the project and the JV will wind up at this point. Next slide. So some key issues to consider in drafting a JV agreement. Of course, the objectives should be well defined to avoid any ambiguity. The contributions of the parties should be well defined. So contributions could be in kind, in form of technical expertise, other resources such as land, which is critical to real estate development, shareholder loans as well. So the agreement will determine how each party brings its contribution and to what the quantum of each party's contribution. The agreement will also provide for capital calls. So at the commencement of the project of the JV, the parties may not all contribute all the funds that they need for execution of the project. So it may be an arrangement where parties are called to contribute as the need arises, and so this is what is called capital call. Now, the JV agreement can provide for whether a capital call will be made by only one party or both parties. And typically, if you are advising a client, you would want to ensure that your client is either the party making the capital call, or if not the party, then the capital call has to be made by all the parties unanimously. And so once a capital call is made and an entity fails to meet its funding requirements, you'll be looking at consequences. What happens when a party fails to meet its funding requirements? Solutions, some consequences rather include the following. So if a party fails to meet its capital requirement, what happens is sometimes the other party may contribute that amount to the company, to the JV, and that amount will, instead of being a straight up equity contribution, it would then be structured as a partner loan. Because it's a partner loan, what happens is, of course, interest on that loan has to be paid first before the parties then share what is left as their returns on equity. It could also be structured as a preferred equity contribution, which has similar effect. So before the profit is shared between all the parties, the party that made the additional contribution gets returns on that preferred equity first, up to a certain agreed percentage. and then the rest is shared among the parties. It could also result in dilution of the other party's shares. So, so in the end, what happens is that the percentage of profits to be shared by the parties then change in favor of the party that made the additional contribution. You could also have a reduction of the promote, as Woye mentioned in his presentation. I believe that by now we understand what a sponsor promote is. So if a sponsor is the one in breach, what could happen is that sponsor's promote could be reduced. The percentage of the sponsor's promote could be reduced. Another effect could be a clawback on fees. So if a party that fails to meet its capital obligations has earned some fees as a result of services provided to the JV, those fees could be clawed back as a result of that failure. So whatever you decide or your clients decide will be informed by the peculiarities of each transaction, of course. Next slide, please. Sorry, go back up. I think there are some things I have missed. Okay, then of course you have the profit and loss sharing, how the profits will be shared, sponsor promote. There's something else I want to mention about sponsor promote. I had already explained how the sponsor promote is calculated, but another thing that you could do is this. So why the returns to a sponsor could be structured like this? If you recall, Woye mentioned that the sponsor is the one that puts the deal together. And so this sponsor promotes, why it's structured like this is to incentivize the sponsor to do more, because the more successful the project is, the higher the sponsors promote. So which is why in some cases, JV structures use the hurdle mechanism. So as I had explained before, say an equity investor's return on investment is 8%. Now, once he gets paid up to 8% of his investments, the rest is then shared, say 70, 75, 25. But if you are acting for a sponsor, you could say, do you know what? The rest will be shared 75, 25, up to a point where the equity investor now gets up to 12% on return of investment. And then the percentage will change. That's the first hurdle. The percentage can then change to maybe 60-40, up to when the equity investor earns up to 60% return on investment. And then the percentage will change again, maybe up to 50-50. I really hope I didn't go too fast there. But essentially what it means is, if the project has a windfall, the sponsor earns more because of your hurdle mechanism. So in the end, it's an incentive for the sponsor. I'm sorry, guys, I have to say this. I got a call from my mom, so I'll call her back when I'm done. So yes, so if you're acting for the sponsor, you want to use this hurdle approach to make sure your client, gets more out of the deal. You have you also want to consider transfer of interest, restriction of transfers, transfers. So if you're acting for a client, one of the concerns partners in JVs typically have is one transferring its interest to someone they don't know, someone they've not had any dealings with, and someone that may be incompatible with them. And so there are usually some restrictions on transfers, such as right of first refusal. So if you're going to transfer your interest, you have to offer it to me first. Other things like drag along rights. So if you're transferring your interest to any third party, you must also get them to acquire my own interest. And so he buys of us out. Tag along rights. Also, if I'm transferring my interest, maybe I'm transferring my interest to a party that wants to buy everything. So I may want to have a drag along right in the agreement, where if I'm selling my interest, I can drag you along, and once a fair price is offered, you are, the other party is obliged to sell off his interest alongside. I mean, there are more technicalities, there are more details about how this works, but we are just discussing most of these issues on a high level basis. Then perfection of interest. So I remember years ago when I had an interview with one of the law firms in Lagos, and a partner asked me about a JV arrangement, JV transaction I had worked on. And then he asked me, if you are acting for a developer and the developer has found a landowner and wants to invest, the landowner has, the title documents. What can you do to ensure that the interest in the land is protected? And so your client does not invest, and then you find out later that the landowner has gone ahead to sell the land to another party. I had quite totally forgotten about that question until just a few years back when I worked on a similar transaction and I happened upon this. So if you are acting for, a developer or an investor who has this concern, one of the things you could do is pending the perfection of the interest, perfection of the title in favor of the JV, one of the things you could do is the title documents of the landowner could be held in escrow by a trustee. So what this means is that the landowner will not be able to use that title document to transfer its title to another party until you've perfected the interest of the JV in the land. And non-compete provisions, because typically as a JV partner, you wouldn't want your partner to go behind your back and set up a similar or competing business that will bring down the profits that you get from your JV arrangements. Next slide, please. You have provisions affecting related party contracts. Aside from the contributions that parties make in equity terms to JV arrangements, parties could also provide services that will be paid for by the JV. But you don't want to have an arrangement where the terms of that agreement are skewed in favor of of a party. And so there are provisions regarding related party contracts, the approvals that must be obtained before one of the parties enters into a contract with the JV. Issues around management and governance, deadlock provisions. I don't know. Did you speak about deadlock provisions when you spoke? Just to know if I.
Not very, so you can actually touch on it.
Okay, great. So a deadlock occurs when in a JV arrangement, you have two parties that have equal rights, equal voting rights, and both of them disagree on an issue, usually a key issue. So you have to, if you don't have a deadlock provision in the JV agreement, it could lead to a breakdown of the business completely. And so you want to have a deadlock provision that will preserve that business, that will preserve that venture, because at the end, what both parties want is to get, some return on the investment. So you need to preserve the venture. And so some of the solutions, some of the approaches that you could use is to have the casting vote provision, where the chairman of the board of directors or the steering committee, with respect to an unincorporated JV, will have a casting vote. And so when there is a tie, the chairman has the right to vote one way or the other. And then again, there are difficulties that could arise where one party would want to be the one to appoint the chairman. So again, these solutions are not particularly watertight. So you just have to find what works in each specific situation. And you could have also the independent manager arrangement where both parties agree to appoint an independent member of the board or independent member into the steering committee who will have that casting vote. So basically, the chairman is not appointed by one person or is not a representative of one person, but an entirely independent entity. And then you have a third-party swing vote where both could agree to refer that issue to an independent expert who then decides one way or the other what direction the company will go. You also have the Texas shootout. So if the parties have so much disagreed that the business can't move forward, you could have Texas. What the Texas shootout provision does is, in practice, what it means is both parties submit sealed bids to buy out each other to a third party. And now that third party opens the sealed bids, and the party with the higher bid gets to buy out the party with the lower bid. And so what happens is one party exists and the other party just keeps operating the business, the joint venture. You also have the Russian roulette, where so instead of submitting the bids to a third party, they offer to buy each other directly out. And so the party, so maybe actually one party offers to buy another party out. So the party that receives the offer could either sell or match or improve on that offer to buy out the initial party. So in the end, one party ends up buying out the other party. Then another method that I have read that is used in places like India is what they call the gin and tonic method, where they have these alternating powers with respect to casting votes. So they could agree that this project is estimated to last for a span of 10 years. So within this 10 years, in year one, whenever there is a deadlock, party A will have the right to break the deadlock. In year two, whenever there's a deadlock, party B will have the right to break that deadlock. But then it's a coin toss, really, because you don't know what year will be more favorable to your client or not. And dispute resolution provisions, you would typically want to have a tiered dispute resolution mechanism with negotiations, discussions, mediation, arbitration, just to ensure. And the essence of this clause is just to ensure that parties are able to resolve the dispute before it really gets out of hand, before it goes to a third party for adjudication. And then it saves time. Another thing you could do in your dispute resolution clause is to have provisions that require that each party should continue to perform its obligation, those of its obligations that are not in dispute, even while the dispute resolution is going on. And so what this does is that the project is not kept at a standstill while the parties are trying to resolve their dispute. It could have provisions regarding consequences of insolvency of a party. So if one party goes insolvent, what happens to the project? Do you want to leave it at the mercy of a liquidator who may sell off the insolvent party shares to another entity that may not be compatible with the remaining JV partner? And so a solution that you could use is to have deemed transfer. So if one party is insolvent, right, you have provisions that will will result in transfer of the insolvent party shares to the remaining JV at a fair market value or at a predetermined price, or the agreement could also have some parameters for calculating the price of the insolvent party's interest at the time. And then you have termination provisions. Next slide. Sorry, just to ask, Akitunde, how many minutes more do I have? Do I even have any time left?
You have 5 minutes more, Mr. Victor.
Okay, thank you. Then I'm going to talk about a type or a structure of joint venture that is called portfolio joint venture. In some other jurisdictions, they can also be called programmatic joint venture. So as we mentioned at the beginning of the presentation, joint ventures are typically for one transaction, specific transactions. But investors and developers are beginning to find that the effort that they make in negotiating joint venture arrangements could be reduced using the portfolio joint venture method. So at each time a project developer finds an opportunity, he then starts looking for investors and starts negotiating afresh. So what if parties enter into a framework sort of arrangement? And that is what a portfolio joint venture, programmatic joint venture is. So parties enter into a framework. So an investor that sees a suitable sponsor, a reliable sponsor, and a reliable sponsor that sees in a reliable investor with steady stream of income may come together and agree to enter into a framework under which they will then seek out specific projects to then execute together, and and those projects, they will then enter into specific joint venture agreements with respect to those projects. Now, the framework agreements could contain, typically the framework agreement does and should contain forms agreement. So that framework agreement could then have the form of the joint venture agreement to be entered per joint venture transaction. Just a minute. I'm using my phone, and so these words are very tiny. I'm trying to bring this up on my laptop screen. So essentially, a portfolio joint venture arrangement is beyond entering into just a single deal, right? And then there are strategic advantages it offers. So if say, and one of the good things about being lawyers or advisors is that your knowledge is not limited to law. So you see a client that actually has a good stream of cash or a good pipeline of projects. One of the things that you could advise the client commercially is to find suitable partners to have this sort of arrangements where they have the framework arrangements and they can benefit from the strategic advantages. Some of the strategic advantages being that the sponsor has the benefit of a steady stream of investment from the equity investor, and then the equity investor has a steady stream of a pipeline of projects that the sponsor will bring, right? So the equity investor doesn't have looking around for projects or for sponsors to partner with. He's confident that this sponsor will keep bringing us a good pipeline of projects. It also reduces time, because once the framework agreements and the form agreements are negotiated, all subsequent agreements will be based off the form agreements and then will require minor work, so which will reduce time cost, a cost of a negotiation as well. And so parties are able to quickly get into the execution of projects. And so some of the things, next slide, please. So in negotiating a portfolio joint venture deal, what you will be looking for or what you will be asking for will depend on what side you are acting for. Now, on the equity investor side, the equity investor will typically want to have, the project sponsor submit all opportunities or potential projects that it finds to the equity investor for assessment and approval. And then for the equity investor to decide whether to fund this project. Again, the equity investor would not want to have any obligation to fund a certain amount of projects. So he would want to have the discretion as to which projects to fund and how many projects to fund. Also, the equity investor would not want to be prohibited from exploring other opportunities. But then, of course, at the other end of the spectrum, you will see the sponsor seeking for something, different things, and that would inform what you negotiate with for if you are on the sponsor side. Of course, if you're on the sponsor side, your client would want discretion as to what projects to present to the equity investor, and would also want to have assurance that any project it presents to the equity investor will be funded by the equity investor. Also, a project sponsor would want to ensure that the equity investor does not compete against the project. So this is contrary to the third objective of the equity investor that I mentioned above. So you as advisor to this project sponsor, you want to ensure that the equity investor does not explore the opportunities that will compete with the interests of your client. And so all these things are what you consider in executing, in drafting the framework agreements. Last slide, I think. Okay, yes. So I think I've already talked about exclusivity, right, and the right of first offer that an equity investor would want. And then one key issue that parties often negotiate in portfolio joint venture investments is pooling of income. Now, what pooling means is, although parties are executing specific projects on a project by project basis under their separate joint venture agreements, sponsors would often prefer that the income or the revenue of each project will be treated as separate. So what this does is that their promote, we've already established what promote means, their promote for each project is secured. While an equity investor would want to pool all the investments, all the revenue together, and maybe at certain intervals, deal or share the revenue. But most sponsors don't want this, because what happens is, if project 1 does very well, the sponsors promote to be good. But if project 2 does badly, it could affect the other projects, lowering the percentage of the sponsor's performance, and inevitably the promotes that the sponsor will get out of the entire project. And so essentially, I think why I put this last part on the other slide is to let us know that there is no hard and fast rule as to what you ask for or what you negotiate for in a joint venture arrangement, in a joint venture agreement. It depends on what side you are acting for, and it's often project specific, considering the risks that a project partner, a JV partner brings, how reliable the project the JV partner is, the track record that JV partner has will inform what you advise your clients to ask for and or not to ask for. Next slide. Next slide, please. Yes, so I'm hoping that at the end of this presentation, nobody is like this, but if you are, Woye and I are available, and hopefully we'll be able to help answer your questions. So thank you.
Thank you very much. Thank you very much. That was very detailed and insightful, and also with a sense of humor. So thank you very much. So we have a question here. The person said, "Great presentation from both," and continues that in Abuja, my experience with most JVs is that they prefer to fund without banks, but rather from off-plan sales to off-takers. What are your thoughts about this structure? What risk factors should we be looking at? And what do you recommend for such structures? Did you get the question?
Okay. Yes. I think I read the question earlier, and I would say that when it comes to funding of any joint venture project, most developers are open to fund without a bank, and the reason is because when you fund with banks, you have to give them your collateral, and some of them are not so open to giving the banks this collateral. But when it comes to off-plan sales, by the time they start the first foundation or second foundation, I mean, the building is already there. Then control of the subscribers, they could either say they want to terminate at any point in time, and they feel it's more secured. With respect to banking also, you discover that banking comes with additional costs on its own. They have to pay interest and all that. So I would say that the risk factor involved when it comes to getting subscribers to fund their project is inconsistency when it comes to payment timelines. Because of course, you evaluate from your offer letter that it's only a 12-month project or 18-month project, and they've paid, there could be inconsistency coming from the fund. But they shy away from the bank because of the other factors I've mentioned. But the bank is actually one of the safest them to use. But so it depends on the person or the developer doing the project anyways. I mean, I would largely recommend banking from funding from banks, So, but I also allow my colleagues to also speak on this. I know he has his own thoughts too. Victor.
Yes. I mean, I agree with you. I agree with you, where that generally, at the bottom of it, most developers prefer debt finance because it may seem expensive at first, but at the end of it, particularly if the project has a very large windfall, it's less expensive because once you pay off the interest, you then have a limitless potential for the equity returns. But then one of the issues one of the things I have issues with would be the double digits interest rates, in Nigeria. With respect to off-plan sales, I think there is a risk of, as Woye mentioned, there's a risk of getting the required amount of subscriptions that you need. And this will depend on a certain number of things. This will depend on your credibility. This will depend on your track record in the industry. And also, the partners that you're working with, how much confidence they give to the public. Because what happens is that sometimes if you start a project like that and you don't get the amount, at least the minimum amount of subscriptions you need, the project may stall and get into trouble. But, one of the things I would say is every project, again, I mean, I kept mentioning this, everything is on a project by project basis with different risks. Some project developers know how to de-risk their projects as much as possible to make it bankable, to make it attractive to the public and to investors. Some other projects come with a lot of doubts. So what would be risky to project 1 may not carry the same amount of risk for project 2. And what may work for project 1 may not particularly work for project 2. So that's my thought.
All right, thank you very much. Thank you for the answers. I hope you got your answer, Mr. Max. Thank you again. So this has been a very insightful session, and thank you everybody for joining in today. I want to believe you all gained tremendous insights from this knowledge sharing session, both from Mr. Victor's perspective and Mr. Woye's perspective. Many thanks to our speakers who took time out during the busy schedules to engage us on this matter. We look forward to having you on subsequent webinars. A very big thank you to our sponsors, African Law Practice, ALP, Famsville, G. Elias and Co., Advocate Law Practice, SPA Ajibade and Co., and DOA for making this webinar possible today. I also want to thank all the attendees for participating in today's webinar. Please note that our next webinar series will be on Tuesday by 1 p.m. and the topic will be on trends and development in spectrum and wireless telecom regulations. You can actually watch our past webinars on our YouTube channel at My ESQ Legal. And again, thank you everyone for attending today. Do enjoy the rest of your day. Bye-bye.